Hearing in the appeal of ScottishPower Limited and others against Commission for Revenue and Customs.
Yes, Mr. Goldberg.
I wonder if I could pick up a few points from yesterday and then indicate where I'm driving to, or hoping to drive to. We were discussing yesterday whether the errors that arose in complaints handling were practically almost unavoidable or less unavoidable. And my Lord Stevens put it to me that it was just a matter of employing a few thousand more people. It was actually much more complex than that, and it's set out in paragraphs 156 to 161 of the FTT decision, which shows this was a serious issue with migrating from 80 old systems on computers to a new system involving experts from outside who turned out not to have the capacity to deal with it, and new experts had to be found. It's not a fundamental point of my case at all. It just indicates that it's a sort of normal trading expenditure, the sort of accident that can happen in the course of a trade. The second point I might make is that what we have to show in this case is that the expenditure was for the purpose of the business. And Mallew and Drummond explains quite clearly what it is the fact finder needs to look for. And that is on page 1150 of the bundle. I hope I've been forgiven for reminding the court of this, but my grandmother always attended my seminars on egg sucking. But when the fact finder has found the facts, that, for example, that an expenditure is wholly and exclusively for the purposes of the business, this court is stuck with those facts. There has been no appeal from them, and indeed the crucial facts are all agreed, not just set out in the first tier tribunal's decision, but on page 1 of the volume we have all the agreed facts, and there are expansions on those facts in the first tier tribunal's decision. And in particular, we chose to enter into the agreements to settle these matters. And that was a matter of choice. We could have done something else. It would have involved fighting. That wouldn't have been good for the business. The relevant passages in the first tier decision are paragraph 35 on page 140, paragraph 110 on page 151, paragraph 113 on page 152, and paragraphs 158 to 172, noting in particular paragraphs 162 to 164 and 169 to 172. And those are all findings of business purpose, and in our submission exclude the possibility of some hidden second purpose. And I'll be coming back to that point shortly. Yesterday afternoon, I was submitting that the decision notices were all show that the regulator's purpose was to obtain compensation for its customers, not penalties. My learned friend says, oh, well, this is a diversion of penalties to the customers. But there wasn't any diversion of penalties, and the regulator wasn't in a position to divert penalties. Penalties go to the consolidated fund and are dealt with not by the regulator, but no doubt by the Treasury. And they are radically different from...
The FTT found at 134 that the regulator's purpose was that the payments should be punishments.
Yes, but if we look at the documents themselves, they say they want compensation and not penalties.
But I thought you said a moment ago, the facts are the facts and you're stuck with the facts.
I'm perfectly content to be stuck with the fact that the regulator decided that these were punishments.
You are happy with that?
I will stand by that. But it isn't the question before you. The question before you is not what does the regulator think.
No, I was just responding to your suggestion that the regulator intended that the payments were by way of compensation.
Well, can we look at the documents on that? Page 284 in the bundle. Paragraph 1.2. The authority considered it appropriate to impose a penalty on SP. However, SP agreed to make contributions amounting to 8.5 million in the form of compensation and payments to vulnerable customers. The authority considered that the payments offered by SP to aid consumers will be of greater benefit to energy customers than if a substantial penalty was imposed. Accordingly, the authority considered that a nominal penalty of £1 should be imposed. I will give you a list of places where they say something like that, but it is quite clear that what they wanted was compensation to customers. And they couldn't have both. They couldn't have both compensation to customers and a penalty of the same amount. So they were choosing to tell the power generator, pay your customers compensation.
Right, but by, you're using compensation in a sort of broader sense there as being the whole of the redress payments rather than just what have so far been referred as the compensatory amounts, which were more targeted at particular customers. So you're referring here as to all the payments, including those that were made to charities and lobby groups or whatever, as being compensation.
Yes.
In a broad sense.
Yes. And that is how the regulator was dealing with them. The regulator knew it couldn't have the penalty and the redress payment, and it chose the redress payment. And if the revenue had turned up and said, you know, that's messing around with our ability to tax, will you please impose a penalty? The regulator would have said, no, we don't want to impose a penalty. We want compensation for our customers. And they've said it in these documents over and over again. May I give you the references, and they're not all of them, but here are the more important ones. Page 291, clause 4.4. 4.4 tells us what the authority is required to do, and it is to look after the interests of its consumers. So it's taking a decision in the best interests of its consumers and want compensation for them, what I'm calling compensation for them. it may be an apology. It's not pound for pound, but it is nonetheless something that can be called compensation. Page 297, clauses 6.8, 6.9. And I note, by the way, that in these passages, the regulator is saying Scottish Power offered to do something. It wasn't saying it was compelled to do something. It offered to do something, and it chose to enter into the agreements as the FTT has found. Page 297, that's 6.8 and 6.9. Page 299, clause 1.9. Page 302, clause 4.3. Page 306, clause 6.1. Page 311, clause 4.2. Page 321, clause 6.1. Page 327, clause 1.4 and clause 1.6. Page 339, clause 4.4. Page 345, clause 6.3. And I don't know why this is out of order. Page 344, clause 6.1 on page 344. And just because there was some issue about it when my learned friend opened, can I note that at page 345, 15 million of the 18 million that was agreed, less £1, was definite compensation to go to warm home discount and priority service register customers. That is real compensation.
To reflect actual loss, no.
It may reflect actual loss because part of it was being kept holding on the phones too long. So the question is, how much is the time worth of the customer? That's one of the things that is taken into account.
Is there anywhere in the papers where all these SLC 25C and 27.17, is there anywhere where those are all set out?
Not in the papers, lady. I think not in the papers.
Is it in the public domain what these service level...
Yes.
I mean, they just refer to all these strings of numbers. It might be useful at some point for us to be able to see what those conditions are. Not now, but presumably the CHR regulations we can find, but...
Yes, and I believe the SLCs, if you...
I don't want to see them if it's some vast 100-page document, but it
Yes.
might be useful for somebody just to look through these decision notices and pick out which of the SLCs and CHRs they refer to. And
well, they all do say. The decision notices say what SLC is in issue and what it's about. Not sure that I can put my...
all right, well, if someone could look at that.
And they are summarised at the start of the FTT's decision in tab 7. paragraph 36. For example, deals with the mis-selling obligation. Then paragraphs 46 and 52 again summarise the relevant provisions. And we, at any rate, were content with these as an accurate summary of what the standard conditions are about. So my submission is that these papers I've just shown you and others in the bundle show that the regulator did not want penalties. He wanted redress payments, not penalties. And these redress payments were substantively different from the penalties. It's not a matter of labelling, as my learned friend says in his case. It's a matter of these things being really different. They do different things. They go to different places. Different people have rights in respect of them. You can't say that they're the same. So if I could just indicate where I hope to be at the end of this morning. My first proposition is that the agreements and decision notices, which I've just given you the references to, push the respondents into the character of traders, paying compensation to customers, not in relation to the redress payments, wrongdoers paying a penalty to the state. And my second main ambition is to show that the reasons given by HMRC for denying a deduction in this case are not really maintainable. Now, those reasons can best be seen in their statement of case at page 72 of the bundle. I'm really picking it up at paragraph 5 in brackets. They say the first reason for a non-deduction is that a regulatory sanction or punishment for misconduct is something that is done to the trader after their profits have been earned. It's not something the trader incurs in order to earn profits. Well, if that's true, I'm not quite sure why the point wasn't taken in McNite, because the legal expenses were clearly not part of earning the profits, other than in the sense of being a general ongoing business expense. So that doesn't seem to us to be a very good point for the revenue, and there isn't a case where a point like that has been taken successfully. My friend showed you 2 cases about tax, but tax is obviously in a totally different category from these payments.
Why is that? Why is it in a totally different category? It comes after the profits have been earned in the same way. The profits would have been the same in either case, without the tax or without the regulatory.
You have to go and look at the source of what the payment is. I'll be showing you the passage in Herald Weekly Times,
Okay.
which says that. And when you do that, you see that in Smith's potatoes, the tax computation goes back to tax figures, not anything to do with potatoes. And that is really why it isn't deductible. But here, it goes back to things which are absolutely inherent in the trade, and I have agreed findings of fact to that effect. So, my submission is that given the agreed findings of fact, coupled with the expansion in the passages from the FTT decision, which I've given you, the proposition put in paragraph 6 of the revenues case is not maintainable. They say the second reason is that the punishment is inherently personal to the entity being punished, and therefore the expense of meeting that punishment fulfills a private rather than a trading purpose, and this is an inherent mixed purpose. Now, if I could take you to Herald at page 1701 of the bundle.
I'm so sorry. Can you give that page number again?
1701. And here, Mr. Justice Dixon is dealing with arguments very similar to those which my learned friend is putting forward at the paragraph, at paragraph 6. It says, none of the libels or supposed libels was published with any other object in view than the sale of the newspaper. The liability to damages was incurred or the claim was encountered because of the very act of publishing the newspaper. That's true in our case. These liabilities arose from the very act of being a power generator selling power. And I have a finding of fact to that effect, which is unchallenged. The thing which produced the assessable income was the thing which exposed the taxpayer to the liability or claim discharged by the expenditure. It's true that when the sums were paid, the taxpayer was actuated in paying them, not by any desire to produce income, but in the case of damages or compensation, by the necessity of satisfying a claim or liability to which it had become subject, and in the case of law costs, by the desirability or urgency of defeating or diminishing such a claim. But this expenditure flows as a necessary or natural consequence from the inclusion of the alleged defamatory matter in the newspaper and its publication. Expenditure in which the taxpayer is repeatedly or recurrently involved in an enterprise or exertion undertaken in order to gain assessable income cannot be excluded simply because the obligation to make it is an unintended consequence which the taxpayer decided to avoid. No point is made of the fact that the publication took place in a former year, and properly so. The continuity of the enterprise requires that the expenditure should be attributed to the year in which it was actually defrayed. And all of that applies to this case. We are meeting a liability which has arisen inevitably from the running of the business. And the argument was put to the first-tier tribunal And the first-tier tribunal discussed it at paragraph 169, and reading that to 172. So Mr. Talon, who appeared at first instance, argues that a reason for the purpose for the payments was the reason Spurl entered into the settlement agreement, namely inter alia to promote the efficient operation of business through the avoidance of litigation risk and the diversion of management time. And we've seen at paragraph 35 that that was indeed the purpose of their choice to enter into it. It achieved the putting to an end of the investigation and the avoidance of a higher penalty, and took advantage of a discount from the penalty Ofgem indicated it would charge. These, he said, were reasons for the payment and were not for the purpose of the trade, which could not be dismissed as intermediate purposes on the way to some ultimate objective. Section 54 applies to prohibit the deduction of an expense incurred otherwise than wholly and exclusively for the purposes of the trade. The expense of the redress payments was incurred because Spurl had breached the relevant requirements. We referred above to the passage in Herald that whether money is expended for the production of income cannot be determined by considering the immediate reason for making payment and ignoring the purpose for which the liability was incurred. And we gave the example of the builder's ton of sand. In the instant case, the liability arose because of the company's purpose in carrying out the acts which gave rise to the breach. Those we have found were for the purposes of the trade. We accept that it is likely that the company agreed to the settlement for the purposes of concluding the investigation, as Mr. Talon relates. But we find, as Mr. Justice Donovan accepted in Great Boulder, that that was for the purposes of the trade as well, putting an end to a time-consuming investigation, avoided expense which would be suffered by the trade. The same must generally be the case for any settlement of a liability which arises from actions taken in the course and for the purposes of a trade. Thus, on the basis of our conclusion as to the trade conducted by Spurl, the expense of the compensatory redress payments was incurred wholly and exclusively for the purpose of the trade. We've found that the other payments were deductible on policy grounds. If we are wrong, we would find that Section 54 did not preclude their deduction. So that is a finding that everything was wholly and exclusively for the...
It's hypothetical. It's a finding on the basis that they're wrong to have concluded that the payments had a punitive or punishment character. If that wasn't the case, the tribunal went on to consider, on that hypothetical basis, what the purpose of the payments was. It's a finding wholly in that hypothetical context, isn't it?
If you say that, if you say it's because of a penalty, it wasn't wholly and exclusively, you have to find some basis for saying that the penalty prevents it from being wholly and exclusively. And I cannot see what prevents, on these findings, it from being wholly and exclusively just because you call it a penalty. And you call it a penalty, but I've shown you the documents. The regulator did not call it a penalty. The regulator called it a redress payment. And if you consider these payments...
The tribunal called it a penalty. They found at paragraph 157 they were non-deductible penalties.
No, I didn't say the tribunal didn't find it to be a penalty. I said the regulator didn't treat it as a penalty.
But in a way, so what? I don't mean that in a rude way. The tribunal did find that the regulator intended these to be punishments, but even if they hoped and intended that the punishments should also compensate and afford redress rather than going to the consolidated fund, it doesn't follow that they were not in the nature of penalties.
The question which has to be addressed is why it is that the penalties, if they are penalties,
Were paid.
are non-deductible.
Well, for what purpose were they paid? Why were they paid? What was their character and why were they paid?
Well,
Isn't that the test?
They were all paid for the purposes which the tribunal has set out with admirable clarity at paragraphs 158 to 172.
Well, that's the alternative basis. The basis on which they found that they were not deductible was that they were in the nature of penalties, and that the purpose for which they were paid was under the threat that, had they not paid them, very more substantial penalties would have been imposed. That's 137.
Well, why is that not a business purpose?
I'm sorry?
Why is that not a business purpose?
Because it's personal to the trader, and because it's paid to reflect punishment rather than to earn profits.
Well, I don't think there's any case which decides that something is non-deductible because it's a penalty, except in the case where there has actually been in form a penalty imposed under a statute. And that is not what happened here. What happened here is much more akin to a payment of damages. It serves the same purpose as a commercial payment of damages. It has the same economic function in the business of the power generator. And I hope to show you in a minute that there is nothing in the case law which says that an agreed payment against the background of a penalty, an agreed payment, not itself a penalty, is non-deductible on the basis that it is a penalty. This is a two-world theory. When two worlds collide, they explode. We're supposed to be looking for harmony here. And what greater disharmony can there be than my learned friend turning up and say, never mind what the regulator call it, never mind what the statute says, I'm calling it a penalty, and I want you to tax the taxpayer on the basis that it's a penalty. When the taxpayer did not enter into an agreement that said, I will pay a substantive penalty, he chose to enter into an agreement that said, I will pay compensation. That was a decision on both sides. That was agreed by both sides. We would not have agreed to the penalty. So where is the principle that says that this will stop being deductible because my learned friend can turn up and call it a penalty when the regulator didn't? And when everybody behaved on the basis that it wasn't a penalty because the money didn't go to the consolidated fund, which is where it should have gone if it was a penalty.
But it doesn't matter where it goes. The question is, what's the nature of the payment? And does the payment have a punitive nature? The destination's really neither here nor there.
No, it does matter, my lord, because what something is must take its nature from the legislative background. And here, the legislative background says a penalty has to go to the consolidated fund. That's section 27A10 of the Act. And this payment did not go to the consolidated fund, so it did not satisfy the statutory requirements for being a penalty. And, for example, I didn't have the appeal rights that I would have had if it had been a penalty. And what is the principle of law that takes away my ability to deduct this so-called penalty?
I'm just wondering if you could help me. Did the total package include an element of deterrence?
That is certainly one of the features that is mentioned in the decision notices.
Yes. And what's the purpose of deterrence?
The question is not what is the purpose of
Well, I mean,
deterrence.
perhaps I rephrase it. Isn't deterrence an aspect of punishment, that you deter the person who has broken the licence conditions and you deter other people from doing exactly the same in the future? Isn't that the purpose of punishment?
Yeah. It's not the purpose of the business.
Well, I just want to clarify, did the total package include deterrence?
I believe it did.
Okay.
I think the decision letters you took us to earlier
Yes.
mentioned
They
deterrence.
do refer to deterrence. Yes.
But if they do include an element of deterrence, isn't that then removed effectively if you can deduct this from your profits and save 25% or whatever of it by putting that burden elsewhere? Then not actually, you've removed the deterrent effect depending on what the uplift was for deterrence. I don't know whether that's how it's calculated, but there is supposed to be a deterrence effect. But isn't that then obviated if you can save the tax on this amount?
If you say that we can't get a deduction for money that we've paid away, you are imposing a second sanction, which is not what you're supposed to do when you're dealing with matters of public policy and so on. You are increasing the sanction. Perhaps we could look at St John's Shipping. And indeed McNite. Lord Hoffman in McNite says you mustn't double the sanction. Until it's page 1502.
Smith's Potato Estates, is that what?
No, it's St John's Shipping. It's about a ship that was overloaded.
We haven't got...
1520.
Sorry?
1520, St John's Shipping.
Yes, my lady, thank you. It's on page 1545. The Act of 1932 imposes a penalty which is itself designed to deprive the offender of the benefits of his crime. It would be a curious thing if the operation could be performed twice, once by the criminal law and then again by the civil. It would be curious, too, if in a case in which the magistrates had thought fit to impose only a nominal fine, their decision could, in effect, be overridden in a civil action. And that is what is being said should happen here. And the court is putting to me arguments about whether it's a punishment or not. It's certainly not one of my purposes to be punished. reminded of the masochist who liked cold baths in the morning. My purpose is not to be punished. My purpose is what the tribunal found it to be, which was to keep the business running, in a nutshell. So I submit, without any doubt, I passed the wholly and exclusively test, leaving aside the question of penalties. And the next question is whether there is something outside Section 54 or on an interpretation of Section 54, and it may be very difficult to tell the difference between the two. Is there something which stops the penalty being deductible when it is an agreed payment? And in our submission, the answer is no. I can stand here and tell the court I've been looking for such a case. The nearest you get is Warnes and Von Glen. And those cases say, look at the section under which this penalty is paid. It says it's a penalty. The taxpayers in that case, those cases, agreed to pay a penalty. We agreed not to pay a penalty. We agreed to pay compensation. In Warnes and in Von Glen, Mr. Justice Rowlatt and the Court of Appeal, respectively, talked about whether the payments were commercial in nature. These payments are commercial in nature. The payment in Warnes and Von Glen were very clearly not commercial in nature. The payments I made are just the sort of payment I may have made without the intervention from the regulator. I did pay £8 million. We know that. It's in the...
I was wondering about that. I mean, if the directors of ScottishPower just decided, for no particular reason, to hand over millions of pounds to a charity for vulnerable people or people suffering from fuel poverty, would that be a proper use of the company's funds for the benefit of the shareholders?
Well, I can't say on the sketchy facts, but I would imagine the company would not do it unless it saw some benefit. And we did pay over. We recognised here that our customer says, we're not talking here about some dreadful deed done in the dark of night. The problem here was they didn't answer the telephone within 6 rings.
Well, that was one aspect of it. There
It's
were
the
4
biggest
different
aspect.
aspects.
It's the biggest aspect. It's the biggest aspect. And it runs through all of them.
But the tribunal found these to be serious breaches.
Yes, because the obligations on them are very high. I'm not sure my chambers answers the phone in 6 rings. It's a difficult obligation to undertake, but they do undertake it, and they accept the organisational risks, but there has to be some commercial sense to what's going on.
But are there cases where the question of whether this is deductible or not can't turn on the background facts of how egregious the breaches were? I would assume that the regulator allows companies to pay to charity rather than pay a penalty, whatever the nature of the breach.
Yes. But the company itself has to decide why to do it. What's its purpose? And the first-tier tribunal has told us what the purpose was. I embrace it wholeheartedly. Paragraph 35 of the decision.
Well, that was the company's purpose, but the FTT also went on to say that inextricably linked with those payments was the regulator having found infractions and punishment being required.
Yes, and I say that is irrelevant.
You say that's irrelevant, but that was the finding.
I'm sorry, I didn't hear the end of that sentence.
That was a finding made by the FTT.
Yes, the FTT found it was a punishment. What I am saying is that there is no authority which makes that relevant. What I am saying is I have my accounts drawn up in accordance with Section 46. My profit excludes the amount I deducted in respect of the redress payments. There's no challenge to that. That was the right thing for me to do. My profit, as a matter of accounting and commerce, is reduced by the redress payments. My learned friend wants it put back. I'm not here saying, give me a deduction. I've got the deduction in the accounts. He has to show that I ought to put it back because of something that he said. What is it that makes me put it back? There is nothing expressed in the statute. It's not Section 46, and if I'm right on wholly and exclusively, it isn't Section 54. So, as I said yesterday in opening, my learned friend is asking you to invent the principle. He cannot point to a case which covers the facts of this case. He can't point, he points to Warnes and Von Glen, but they are distinguishable on at least two grounds. One, they deal with non-commercial payments, and these are, in a sense, commercial. They're the sort of thing you can imagine a business doing. Businesses do give to charity. And they were, in a strict sense, penalties. So, as it's put in Herald Tribune, in those circumstances, that severs it from the nature of trading.
And do you say they're, in a strict sense, penalties simply because there was a statutory provision that provided for the payments, whereas there isn't in this case?
Yes. In Warnes and Von Glen.
Yes, yes. Yeah.
Not here.
No, I know.
The statutory... He cannot show you a statutory provision that says these are penalties.
They missed a trick in McNite then. They missed a trick in McNite because there wasn't a statutory provision there.
Well, I don't know whether they missed a trick.
Sorry, in McNite it was treated as a penalty, albeit obiter, even though there wasn't a statutory provision.
Indeed. But there was a provision which said pay a penalty.
Yeah, it was a contractual provision. It was the internal arrangements for the market.
Yes. But it talked about penalties.
So?
But here I haven't... The redress payments that I paid were not a penalty.
Well, is the dividing line whether there is a statutory provision which describes it as a penalty, or is the dividing line that there is some sort of description of it being a penalty in some other document?
My submission is that the authorities, as far as they go, deal with statutory penalties. The Warnes and Von Blair.
Yeah.
Whether it goes further, Maybe it does. But however far it goes, it doesn't cover this case. Because
it's voluntary. Because
it's
an agreement.
voluntary.
Yeah.
And everybody involved in it knew this was not a penalty in form. So it may have something to do with form, but the form here was expressly not a penalty. And the substance was not a penalty because it's going to the wrong place. And we really cannot dismiss this as, oh, insignificant. Oh, no. It's gone to a charity. Never mind. We'll treat it as having gone to the consolidated fund. It's not good enough. It doesn't recognise the truth.
So it's not a penalty in form because everyone agreed that the redress payment would be made. And one ignores the element of deterrence in that total package.
Yes. Looked at from the angle you're supposed to look at it from,
Yeah.
which is the trader's angle.
Yeah.
Why has he paid it? His purpose is not to be deterred. His purpose is to get on with the business. In our submission, there's no evidence of any form of dual purpose here, and there's no reason for the law to impose a dual purpose. And McNite, to leap ahead a bit, really has nothing to do with this. It certainly did not decide that redress payments or agreed payments are non-deductible. What it decided was that legal expenses were deductible. Everything else is commentary. And there's nothing in the headnote, for example, to suggest that McNite is authority for the proposition that agreed payments are non-deductible if they have some kind of penalty element. There's nothing about it. It's all a discussion of something that was, in form, a penalty. And that was not before the House of Lords in any event, because there was no claim to deduct the penalty. In our submission, the documents you have push the payments into the character of trader, push the payments made by my client into payments made in their character as trader, not as wrongdoer. In a sense, the regulator has said, I want you to deal with this matter as between supplier and consumer. And in a sense, the regulator has internalized the payments and made them part of the trade. And the character in which they're paid would have been totally different if these were expressed to be penalties.
Can I just be clear in my own mind? As far as penalties are concerned, penalties that are called that under the legislation and by whatever regulator, you accept that those are not deductible, but can you clarify whether you accept that because you accept that a penalty, properly so called, is not incurred wholly and exclusively for the purposes of the business? Or do you say, and I think on your reading of the FTT, this is what they decided, yes, it is still something incurred wholly and exclusively for the purpose of the business, but there's some judge-made public policy rule that precludes its being deducted. Which of those two, or maybe you say both, in some order or other, but I'd like to clarify which of those is your case.
I think, standing where I am stuck with both. I do not believe it is right that as a matter of public policy, some dual purpose should be...
No, I just understand that, but you have always maintained the distinction between the penalty and a not penalty, but I just want to understand on what basis. But you've answered me to say you both think that it's a penalty, properly so called and so characterised, is not incurred wholly and exclusively for the purpose of the business, but it's also there's a public policy for not allowing it to be deductible from profits.
I think if I lay my soul bare, what I really think is I'm not going to win a case about penalties, so don't waste your time trying.
But we have to arrive at some kind of principle, Mr. Goldberg.
Yeah.
So
I mean, say, for example, I'm a barrister and I'm due to appear in court at 10:30, and I'm in a strange town. I can't find anywhere to park my car, so I leave it on a 10:25. I leave it on a yellow line outside the courtroom, and I go in and do my job. And in the meantime, I get a parking fine. Now, I've only incurred that parking fine because the imperative was to perform my professional duties. Did I incur that fine wholly and exclusively for the purposes of my trade as a barrister?
In a case like that, and this may be an answer to Milady, where the fine is imposed, there may not be a purpose. There's nothing proactive coming from me. I'm hit with custard in the face, and I don't have any choice about it. So that may be an answer as to why there's no deduction for the fine. But here we get into very fine cases. Supposing you park on a private piece of land and there's a sign up saying free for the first 2 hours, and then a penalty of £100. Is the £100 deductible for the bounce?
Is it?
And are you saying that's different because it's a contractual arrangement under which the £100 is payable rather than a statutory fine imposed for a break of the law?
Yes.
Right.
But so there may be very fine distinctions to be made, but my submission is that in this case I'm entirely on the right side of the line because the regulator said you're doing this as trader, not as wrongdoer. And perhaps I can show you that character is important when you come to pay. In looking at 3 cases, Strong and Woodyfield on page 1552. On the bottom half of the page, it talks about the character in which you pay. They fall on the trader in some character other than that of a trader. And then if we look at Rushton and Heel at page 1475. At the top of the page.
And they're talking about Strong and Woodfield there.
Yes. Can I just... Can I just come back to the car parking? It may be when there is a fine, you've got a double yellow line that you park on, it may be there is a public policy reason for saying that it should be non-deductible. But there can be no equivalent public policy reason for the private car park. So that may be a distinction that is useful here, but in our submission, there is no public policy reason for denying the deduction in this case, where the regulator wanted it not to be a penalty. I'll come back to that.
Well, parking illegally would be in connection with the profession. It wouldn't necessarily be for the purposes of the profession.
I think if you park legally, we would all expect to get a deduction for the car parking fee.
Really? Illegally?
No, legally.
Oh, legally, yes. Sorry,
Yes.
I thought we said
Yes.
illegal.
No, if we, sorry.
Sorry.
If we park legally, we'd all expect.
Yes.
If
Yes.
that indicates that it's for the purposes of the trade.
So say we have two barristers on either side of a case, and one of them parks at a parking meter or something of the kind, which is regulated by criminal law, and the other one parks in a private car park, and they both expect the hearing will last 2 hours, and they pay the appropriate amount for 2 hours, but in fact the hearing goes on into a third hour, and they both receive a penalty. The barrister who parked in the private car park can set the penalty against his tax bill, but the barrister who parked on the street and overran the meter, he can't. Is that the position?
I believe that to be so, because in relation to the law providing you can't park, there may very well be a public policy reason. There's another point to make here. Just because it is called a penalty doesn't mean it's a penalty. In the private car park, it's just an extra charge. And you can call it green cheese if you want to. But it remains an extra charge for parking and is non-deductible. And that is what has happened in this case.
Whereas, I mean, the way Lord Hoffman approached it in McNite was to talk about the legislative purpose being undermined by tax deductibility.
Yeah.
And the legislative purpose of having restrictions on street parking, one might say, applying his reasoning, would be undermined if the parking fine could be set against tax.
Yes.
Right.
Yes. It's very unclear as to the legislative purpose of the provision that Lord Hoffman had in mind, because with the greatest respect, it seems to wander from Section 54 to the stockbrokers' rules and back again. And in the end, he only says may, be non-deductible. He doesn't say it will be. And the last case on this I wanted to show you is Smith's Potato at page 1513.
Yes, Mr. Gelberg.
So I was asking you to look at Smith's Potato at page 1513. In the middle of the page, again, there is a reference to the character in which the taxpayer is making the payment. And it is my submission that in our case, the taxpayer is paying as a trader. That's why he's paying the consumers, the customers.
Yeah. That's rather like the innkeeper case, isn't it? So you would say that your clients in this case were paying as traders.
And I would say that the finding of fact by the first tier tribunal support that completely.
Yes. So that's a mistake.
And there's no legislative purpose being defeated here, because given my acceptance that if the regulator imposed a penalty, it would be non-deductible, the regulator has a choice as to how to deal with the matter. The regulator can impose a penalty, and then it's non-deductible. The regulator might impose a consumer redress order, and then you might or might not get a deduction depending on the precise facts, as there'd be a question as to whether the payment was imposed or not, so that the payer did not have an unfettered purpose in making the payment. Or you may agree with the power generator that payments will be made, and in that case, as here, in our submission, there should be a deduction. So the regulator has a complete choice as to what to do. And if he wants to impose the penalty of not being able to keep the money you've made and paying it away to the consolidated fund, he can do that, and he will know that that imposes a second penalty of non-deductibility on the taxpayer. Or he can take a shot at a consumer redress order, or he can do what he's done in this case, and what we know he is still doing from the British Gas example, which is to enter into an agreement which is voluntary and capable of being for a purpose which the taxpayer himself has. And the court of...
saying then that if we were to decide in your favour that this was deductible, that is then a factor that the regulator can and should take into account when deciding in future whether to impose the trying to think of a a neutral word, the payment, as A, a penalty, B, a consumer redress order, or C, an agreement of the kind that we had here?
I'm saying it's certainly a factor which he can take into account if he wants to.
Really? Is that public law relevant?
Is there?
Is that public law relevant for the regulator to take into account the tax consequences?
Why not? He's supposed to look after the interests of consumers generally.
Well, but not to consider whether there should be tax deductibility of the payment or not. Surely that's an irrelevant factor for the regulator.
Not at all. If it's looking for the overall benefit of consumers.
But how does it benefit consumers if it's tax deductible or not deductible? It may benefit taxpayers, but surely taxpayers aren't part of the purpose of the regulator.
It may indeed be part of the deterrence that the regulator can take into account. If the purpose is to deter, you deter all the more if you say this is non-deductible. But you need to do it knowing what you're doing. The only point I'm making here is there cannot be any public law reason for inventing a rule, and you would be inventing the rule, that says this is non-deductible because it has something to do with the regulated industry. So there are very strong policy reasons for encouraging settlement. And if you say these payments are non-deductible, that is going to discourage the making of settlements. And that would be a bad thing, because the regulator has said making settlements is in the interest of consumers generally, because it achieves a faster resolution than going through all the formality.
Well, it may be said that it would be neutral. It will certainly be deductible, non-deductible if it's a penalty in form and substance. And so if it's non-deductible because it's a punishment not described as a penalty in form, it's a neutral point if it's non-deductible, isn't it?
Neutral for who?
For the trader. He's still going to pay less because the regulator's going to discount it. I can't see how it will discourage settlements. It's neutral. That's what I'm putting to you.
Sorry, the regulator's going to discount it. Well, if we come to an agreement.
The regulator
yes.
has identified, say, a penalty of 25 million. He's going to give a discount if you settle within a certain period of time. And it's up then to the trader to make a decision about it.
Yes, and what we've done in this case is negotiate, and we didn't pay a penalty of 25 million.
But just looking at it, just to understand how this works, if you look at page 418, right, there are two different things. There's the discount on the penalty for paying early. And if you agree early settlement, then the proposed penalty is 18 million. But you can also then agree that 18 million will be paid to charity, say, rather than by way of a penalty. So as I read this, you don't get an extra discount for making a redress payment rather than paying a penalty. You get a discount on the penalty for early payment, and then that amount is converted into redress payments.
we never agreed a penalty. We just never agreed that. That was not the deal that we did.
Yes, but you didn't get the discount because you agreed to pay it to charity. You got the discount because you stopped fighting the investigation.
Yes, and that's a very good business purpose.
But you would have had that same business purpose if you'd said, all right, well, we won't fight anymore. You say on the 21st of April, we will pay you a penalty of 18 million.
But then I would have had a different suite of documents and a different agreement. The agreement I entered into was an agreement to pay in relation to complaints handling 18 million, 15 million of which was certainly dedicated to my consumers. I entered into an agreement. Let me see. The fact that Ofgem named a figure does not mean that that's the figure that's going to be paid. If we look at the tribunal decision at paragraphs 38 and 39 and 48, we'll see that we negotiated the payment down. So these are the agreements that were actually made. My point here is that the regulator has a choice as to what to do. There is no reason why public law, public policy should intervene to prevent the deduction of the redress payments. In any event, in our submission, everybody involved in this case is constrained by Section 46 of the Corporation Tax Act 2009, which is at page 514 of the bundle, and by what this court said in NCL Investments, which is at page 1332 of the bundle and paragraph 29. And those provisions, that provision and the comments made in NCL constrain the court not to invent a new principle. So if the court is going to say that these payments are non-deductible, it must be satisfied that there is some existing principle which mandates that conclusion. I think my learned friend told you yesterday that there are something like 2,700 sections in the Corporation Tax Acts dealing with the imposition of corporation tax. It is a relief to know that only one of them is apparently relevant in this case, and it is section 54. And the argument that is put against me is that there is something in section 54 which denies a deduction for a payment which in every other respect is wholly and exclusively for the purposes of the trade. And my question, I appreciate I have to provide an answer, but my question is, what is it? One answer may be there is a requirement that the payment is adequately connected to the trade. And there is a useful passage in Shepherd and McNite at page 1186. No, sorry, I think 1160. Well, I show you 1160 to show you what the head note in the tax cases report says it was about.
So what's the page number, sorry?
1160.
1160. Thank you very much indeed.
So this is the head, is this still the head note or?
Yes.
Yeah.
This is the head note of the tax cases report. And paragraph 1 is the important one. The test in section 130A, wholly and exclusively, is a single test. The requirement that expenditure must be sufficiently connected with the carrying on and earning of profits in the trade does not constitute a separate and additional test, but is only an aid to deciding whether or not the test in section 130A has been satisfied. In any event, the Special Commission has not been asked to determine whether the legal expenses have been incurred outside the course of the trade, and they made no findings which would enable an appellate tribunal to determine that question for itself. So, in that case, the claim to deny the deduction was that the payment wasn't sufficiently connected with the trade.
But that was the Court of Appeal's decision.
That was the Court of Appeal decision. And we see the relevant passage on page 1186 of the bundle in the judgment of Lord Justice Norris. At letters G to I. So in that case, the attempt to deny the deduction was based on insufficient connection. In this case, it's not so tightly confined. It just apparently is not wholly and exclusively, despite all the findings of fact. But whatever it is, it's one test. And there are all sorts of factors you can throw into it to see if the test is satisfied. And I've suggested character is one of them. How far is it in the course of the trade is another. In response to that, the revenue say, well, it's an after effect of trading rather than in the course of trading. But Herald Weekly Tribune, Herald Weekly Times, shows that you need to look at the actions which give rise to the liability. And I showed you that passage a little earlier this morning. And in our submission, once you look back to the source, not answering the telephone, you can't say this is an after effect of trading. It just doesn't fit the facts at all. And equally, you can't say, well, this again is just another aspect of whether it's wholly and exclusively. You can't say that here it is an application of earned profit rather than of expenditure to earn profits, which is what is said in Smith Potato and O'Dowdle. They're wrapped up with the question of character in which you're making the payment. And in our submission, we are totally different from Smith Potato and Dowdle, because clearly these payments arose from the running of the trade, in the course of running the trade, and my findings of fact support that. As I say, there was no suggestion in McNite that the legal expenses were an after effect of the trading, and you would have thought on the facts of McNite that the expenses would be capable of being an afterthought, if anything was capable of being an afterthought. So this is a new thought from the revenue, but it's an afterthought. It's an afterthought for them as well. And it's not a very good thought, if I may say so. So this brings me to the revenue's other point, which is the one at paragraph 6, in brackets, of their case on page 72, which is that there is an implicit hidden purpose. The argument appears to be based on an analogy with Manillieu and Drummond at page 1152. But in that case, the fact-finding tribunal found a dual purpose, and it was at page 1152 of the bundle. And here, the tribunal has not found a dual purpose. And in our submission, in the light of the facts found by the tribunal, there is no possibility of finding a dual purpose. And the crucial facts in relation to that, I've already given you the references, but if I may, I'll give them again. In the agreed statement of facts, to take them in the short form, at paragraphs 53, particularly to 55, at page 21, and these are agreed facts, and forgive me for reading them out. All of the settlement agreements described above were the result of negotiations between SPERL and Ofgem. SPERL was not compelled by force or by law to enter into any of them. It could in each case have refused to settle and either accepted a penalty or appealed against a penalty imposed by GEMA. SPERL chose to enter into the settlement agreements. I want to emphasise chose, because in most cases where there is a penalty, the lack of choice overwhelms every other aspect of the matter and precludes there being a business purpose. But that doesn't happen here. We have the choice. SPERL chose to enter into the settlement agreements for the following reasons. Settlement avoided the risks inherent in litigation, the possible adverse effects on its reputation of a large penalty, and a diversion of management time in bringing the investigations to a close or litigating a penalty. Settlement avoided adverse publicity and damage to SPERL's brand, and maintained goodwill with Ofgem. Payments to consumers also promoted goodwill with them. And settlement tended to compensate and could, where possible, be directed to those who'd suffered harm. SPERL preferred to make payments for the benefit of consumers rather than paying monies to the exchequer. The essence of SPERL's trade was selling gas and electric energy. The settlement payments to consumers or charities, the redress payments, were a consequence of not meeting the standards required of energy suppliers. The acts or inactions that gave rise to the redress payments were part of the activity of SPERL's trade and were done for the purpose of earning income from that trade. So those are the purposes that the first-tier tribunal found were those for which SPERL entered into the agreements. And paragraph 56 is also relevant. And all the way through to 59. And it is our submission that in the face of those unchallenged findings, they're agreed. It's not suggested they're in any way wrong. There is no room for the introduction of some spooky second purpose of which SPERL was unaware. It really defies reality. So then the revenue try to support this unreal argument with the argument that it's a penalty. But there's nothing in the statute about this being a penalty or a punishment. This is not a statutory idea at all. I'm not quite sure where it comes from. I think it's supposed to come from McNite, but McNite is a case about something totally different. Anyway, my first point is there's nothing in the statute.
And when you say nothing in the statute, do you mean in the Ofgem regulatory world, or do you mean in section 54?
I suppose I mean both, actually.
Both.
Yes. Certainly, Certainly there's nothing in the Tax Acts about penalty. Right? Interesting, I did a search, probably inadequate, but anyway, I did a search of common law tax systems. And in the United States at one time, there was an express denial of relief for a payment of a penalty. I'm not sure it's still there, but there was at one time. Other systems with which I'm semi-familiar around the world don't have the word penalty. They have systems based on what I like to think of as the Imperial Code. And they have a very similar test for deductibility as we have here in Section 54. I couldn't find a case like this. It doesn't appear to exist. And so my first answer that the characterization is of a penalty is the statute doesn't ask that question. And my second answer is the question isn't relevant to the one being asked by the statute. The statute asks, what is the purpose of the taxpayer? It doesn't ask, what is the purpose of the regulator? And as the Court of Appeal rightly held at paragraphs 72 and 73 of its decision, at page 112 of the bundle, the purpose of the regulator is not relevant. And the Court of Appeal also rightly held that the redress payments were not and cannot be equated with penalties, and they gave their reasons for that at paragraph 68 on page 111 of the bundle. And another reason is that when there's a statutory scheme which provides for penalties, and the person charged with imposing a penalty decides not to do it, it's necessary in determining whether what happens involves a penalty or not to take account of the deliberate decision of the administrator not to impose a penalty. And if the payments in this case are for some reason non-deductible, it does have to be explained why damages for breach of contract or for tort are deductible when they're connected with the trade. There really is no substantive difference between the redress payments and damages for breach of contract or damages for tort. And I think it's useful to speculate on this question. Supposing there were no provision for penalties in the Electricity Act, supposing Section 27A was not there, what would the position be? If the primary obligation of the regulator had been to agree redress payments, what would be the basis of the revenues argument? They wouldn't have this argument about penalties. they wouldn't have an argument about dual purpose. So if that were the position, if 27A weren't there, it would be difficult to see how a deduction could successfully be refused for the redress payments. If that's right, the real question in this case is whether the presence of an unexercised power to impose a penalty changes a deductible payment into a non-deductible payment. It seems unlikely. So, in our submission, if there is a rule denying deductibility in circumstances like these, it must be found in the case law. And in my submission, you're not going to find it in the case law. I've already made brief submissions about Warnes and Von Glen. I don't know if you'd like me to take you to the passages I rely on. I can do it quite quickly. Perhaps I should do that. It's page 117. I think that's the wrong reference. Maybe 717.
Sorry, 7.
It's gone walkabout. I think it's 717.
Yep, it is.
It is. And if we go back to Warnes on page 709, there's a sort of confusion in this case because there's a provision about wholly expenditure, wholly and exclusively for the purpose of the trade, and there's also a provision about a loss incurred in the trade. The revenue nowadays tend to rely on A, wholly and exclusively for the purpose of the trade, and they don't rely on B. Back after the First World War, they were fonder of relying on B, the loss on capital. But everybody has agreed, really, that these are the same tests, so it doesn't matter. And Mr. Justice Rowlatt says on page 717, about a third of the way down, but the question is whether, within the meaning of the rule, it is a loss connected with or arising out of their trade. I'll shelter behind Strong and Woodyfield. But it seems to me that a penal liability of this kind cannot be regarded as a loss connected with or arising out of a trade. I think that a loss connected with or arising out of a trade must at any rate amount to something in the nature of a loss which is contemplable and in the nature of a commercial loss. I don't intend that to be an exhaustive definition, but it'll try. I think it's a very good attempt, if I may say so, at saying you're looking for something which has an inherently trading nature, like compensation to customers. And the Court of Appeal in Von Glen picked that up. But they also make the point that this was a penalty under the subject, under the statute. And we see that picking it up at the bottom of page 727. The money which is paid is money paid as a penalty. And it does not matter in the least that the Attorney General elected to take treble the value of the goods nor does it matter that it may be called in the information a forfeiture. It is, in fact, under the section, a penalty. So that is what was important there. And then at various places, bottom of page 729, he talks about the character of the payment, of the person making the payment, and then he does that at the top of 730. Character. And then he talks about commercial loss at the top of page 731. Lord Justice Warrington makes the point they had incurred a penalty. And Lord Justice Warrington at page 734 picks up the need for it to be a commercial loss connected with or arising out of the trade. And Lord Justice Scrutton refers to them as penalties. Lord Justice Scrutton refers to them as penalties on page 735. So everybody is dealing with the matter on the basis that there is a penalty. And that is what the statute provides for. And that distinguishes our case from that case. And leaving aside for a moment McNite, it means there is no law that says an agreed redress payment of the kind we have here is non-deductible. And the question then is whether McNite, which is about something completely different, conjures this rule out of thin air in a Mephistophelian effect. Just before I go to look at McNite, I note that I haven't found anywhere in the world a denial of a deduction for an agreed payment of the kind we have here. It is sometimes said, when you can't find authority for a proposition, it's because it's obvious. And so perhaps it is obvious here. But I hope to persuade you that there is no law here and that you are constrained by Section 46 and what this court said in NCL, not to invent the law and create a rule that denies deductibility for something that is otherwise deductible. Now, because I have not brought a penalty before you, I don't think I need to ask you to decide whether the rule is a matter of interpretation of the rule for which my learned friend is asking is a matter of interpreting Section 54 or a matter of a judge-made rule outside Section 54.
Well, the revenue say it's this is Section 54.
They do indeed say it is Section 54.
So you may not have to ask us to decide that, but the revenue are asking us. So do you have a view?
As to, do I have a view? I suppose I have lots of views. I don't believe there is a judge-made rule. So, although the Court of Appeal said it was difficult to fit this into Section 54, I think my preference would be to say that it has to be Section 54 or nothing. And of course, as your ladyship knows, I say it isn't Section 54.
Yes.
So the question then is, what does McNite decide? And I've put in the bundle both versions of the report that are available. Because I'm using tab numbers. The weekly law reports version is at page 1194. And what it only decides something about legal expenses. And it decides that they can be wholly and exclusively. My primary point on McNite is that it's so factually different from this case that it can really tell us nothing about it. There's been a recent reaffirmation in this court in Finzi, which is at page 811 of the bundle, of what the doctrine of precedent is all about. And it isn't about making things up. I think it's page 811. In paragraph 60. Important not to lose sight of the basic tenets of common law. Lady Rose, in the recent case of Orsted, has made the point at paragraph 81 of the decision that you expect to find what the case is authority for in the head note. And so you do. And there's nothing in the head note to McNite that says anything about anything remotely like this case. So, in our submission, taking account of the limits of the doctrine of precedent, McNite cannot tell us anything relevant to this case. It certainly doesn't tell us anything controlling about this case, because there's nothing in it about the situation we have here. I think it's fair to say Lord Hoffman is talking about cases where there are actual penalties. He certainly doesn't suggest that what he's saying goes wider. He doesn't mention anything about agreed payments, anything like that. He talks only of penalties. And we are dealing here, in my submission, with non-penalties. And once you have said, really, this is a non-penalty, then it becomes almost identical with legal expenses and damages. It's very, very difficult to see why those are deductible and the payment we have here is not. And we should note that Lord Hoffman does not say that penalties are always non-deductible. He says, well, I think, while I've got it open, it's worth looking at what he says at page 1195 as to what the case is about. The respondent taxpayer is a stockbroker who incurred legal expenses defending himself against proceedings before the disciplinary committee of the Stock Exchange and appearing before the appeals committee. The question is whether the deduction of these expenses for the purpose of computing the taxpayer's profits under case 1 of Schedule D is excluded by section 130A, that's 54A, on the ground that it was not money wholly and exclusively laid out or expended for the purposes of the trade. So this is a case about whether legal expenses are wholly and exclusively laid out for the purposes of the trade. And the answer is that they were. And it's perhaps worth bearing in mind that in this case there was a large personal element involved, but the Special Commissioner decided that preservation of his own personal reputation was not the purpose with which he had incurred the expenses. He incurred the expenses solely for the business purpose. And the revenue had a thorough go at that. They said, that can't be right. He must have a dual purpose. And they lost on that point because the Special Commissioner had found, very much as the first-tier tribunal found here, that the payments were wholly and exclusively, notwithstanding all the surrounding noise that might have given an excuse for saying otherwise. The court was bound by the finding of fact. So he says at the bottom of page 1198 that the broad general principles of what counts as an allowable deduction. The reason, in my opinion, is much more specific and relates to the particular character of a fine or penalty. Its purpose is to punish the taxpayer, and a court may easily conclude that the legislative policy would be diluted if the taxpayer were allowed to share the burden with the rest of the community. So he is not saying that penalties are always non-deductible. He is saying they may be one of the factors that goes into discussing deductibility, that the payment can be described as a penalty. And then you have to see whether even so it's wholly and exclusively. And he is leaving open the possibility that it can be wholly and exclusively. He's certainly not ruling out. And he points out that if you don't have a rule that expenses are deductible, you're going to get into difficulties with partially successful defences, successes which are morally satisfactory but don't win. And he says at the bottom of page 1199, at later Ench, he may have had substantial success in mitigation of the penalty. More important, it is fundamental that everyone, guilty or not guilty, should be entitled to defend themselves. I do not see that any clear policy would be infringed by allowing the deduction of the legal expenses incurred in resisting the disciplinary proceedings. On the contrary, I think that non-deductibility would be in effect an additional fine or penalty for which the regulatory scheme does not provide. And that's important in our case. Because what policy would be served by saying that the taxpayer cannot deduct these payments? One thing it will do is to stop settlement agreements. And that isn't going to be in anybody's interest. So if this is a public policy matter, the public policy is all pointing towards deductibility. And so in our submission, McNite tells us nothing useful in relation to the issue you have in this case. And that being the case, the deductibility of the redress payments raises a standard, wholly and exclusively question, without any issue of penalties. And as to that, the findings of fact are all in my favour. And there is no special rule to be brought into account. And as I understand what my learned friend said yesterday, he is not arguing for a special rule. He is arguing for Section 54. Now, there are a number of cases since McNite, cases like McLaren and G4S and BES. They are all at a much lower level than this court. They certainly don't bind this court. And in my submission, they don't show, if I may put it this way, any innovative thought. They don't raise new avenues. They're all explicable in accordance with the theory that I've put to you. And so that brings me to the issue of public policy and ex terpi causa. And I think, although I suspect I have 10 minutes, I think I shall be quite short on that. There are 2 points here. First, so far as my learned friend is relying on ex terpi causa, there is at least room for doubt as to whether there is any turpitude here. Essentially, the redress payments operate in the private sector, not the public sector. You cannot describe what happened here as quasi-criminal, and it would be quite wrong to extend the doctrine of ex turpi causa to this principle. The second point to make is that the doctrine is all about, under modern theory, the doctrine is all about maintaining harmony. And harmony is maintained by accepting that for all purposes the payments had the character which the regulator gave them. And the regulator gave them the character of redress payments. It did not give them the character of penalties. And in those circumstances, it is not open to the revenue to come along and say, let me tax them in another world. Let me tax them in a world in which they had paid penalties. That would be disharmonious. It would be asking the court to be schizophrenic and to do one thing in one area and another thing in another area. And it's not permitted, and it shouldn't be permitted. And the third point to make is the question, what is my profit, does not respond to the question ex turpi causa. The question, what is my profit, is a much more hard-edged accounting question, adjusted by Section 54. And my learned friend doesn't need ex turpi causa if he wins on anything else. And if he wins on anything else, why on earth does he need ex turpi causa? In other words, there really is no room for public policy in this area to interfere in the computation of profits. I think I've made it. Lord, unless I can, my ladies, unless I can help you further, those are my submissions.
Thank you very much indeed, Mr. Gilberg. Mr. Ewart.
The starting point in our submission is that there is no statutory tax provision about penalties, as my learned friend said. So there's no provision that says penalties are not deductible. If there were, what your lordships and ladyships would be doing today would be construing that provision and deciding whether on a proper construction it included these payments. That's not what we're doing. The non-deductibility of penalties depends upon, not that they're a penalty per se, but the nature of the payments as penalties. And that is what Lord Hoffman said in McNite on page 1198, near the bottom, where he said, they, that is the Court of Appeal in Von Glen, hope to find the answer in the broad general principles of what counts as an allowable deduction. But the reason, in my opinion, is more specific and relates to the particular character of a fine or penalty. Its purpose is to punish the taxpayer, and a court may easily conclude that the legislative policy would be diluted, etc. So what he is quite rightly doing is looking at the character of a fine or penalty, and that's the reason that it's not deductible in my submission.
He puts it, he encapsulates it again on the following page at letter B, where he says, in a case like this, non-deductibility depends upon the nature of the expenditure and the specific policy of the rule under which it became payable.
Exactly, yes. And we say that the reason that these payments are not deductible is essentially because of the nature of the payments, which is the same as the nature of the penalty. And we rely upon the findings of the first-tier tribunal, which I've taken you to an opening, that these payments were not compensatory apart from the one small element, and also that they were in the character of deterrence. And the tribunal found that in paragraphs 135 and 139 of the decision. And that was the basis on which they decided that the payments were not deductible. Can I just take you to a short passage also in Mallew and Drummond while we're in the same bundle for me? It's at page 1150. It's part of the decision that's not often perhaps looked at, but it's explaining, at the top of page 1150, Lord Brightman's explaining the effect of paragraph A, that's the wholly and exclusively rule. And he then refers to Lord Davy in Strong and Woodfield as being the construction for the purpose of enabling a person to carry on and earn profits, and then makes the point which my Lord Stevens made, which it's not for the purposes of the trader, but it's for the purposes of the trade, which is a different concept, he says. Although the purposes are the intentions or objects of the taxpayer are fundamental to the application of the paragraph. And then he goes on to explain that exclusively is precluding a deduction if it not only serves the purposes of the trade, but also some other purpose, perhaps a private purpose. It can also be that a payment...
But if he says that's a kind of rather odd sentence, they refer to the purposes of the business, which is a different concept, although the purposes, i.e. the intentions or object of the taxpayer, are fundamental to the application of the paragraph. So I'm not quite sure what...
I think he means by that the trader. The taxpayer is the trader. So it is, of course, important to look at what the purposes of the trader are to decide whether it's for the purposes of the trade.
Okay.
Because the trader is carrying on the trade. But the objects might be, in some cases, to further the purposes of somebody else, not the taxpayer at all. Common examples of that are payments. There are cases about this, payments for the purposes of the trade of another company in the group, for instance. There might be situations where a company A pays the salary of an employee who works both for company A and for company B. And so it might be argued it's for the purposes of the trade of company A, but also for the purposes of the trade of company B, and therefore it's not deductible. There are some cases on that. The other common example is where it's for the purposes of, in the context of a family company, let's say, and for the purposes of a member of the family. So maybe the shareholder's daughter might be involved in some sporting activity, and the company will sponsor it. That's quite a common example. And the question might be then, is that wholly and exclusively for the purposes of the trade of the company in providing advertising and PR, etc., or is it also for a private purpose of the taxpayer's, the shareholder's daughter in carrying on their sporting activity? But the point also that's made in Mallew, of course, very important point, is it's not concluded by the subjective purposes in the minds of the trader at the time in which they incur the expense. Some things are an object, and very often in these cases that I've mentioned, the trader will say it's for the purposes of my trade, that's why I justify it, but it actually is apparent from the facts that it's also an object, it's the purposes of someone else's trade. So this is not a game, so long as you are thinking the right thing at the right time, then you get a deduction. Turning then to the FTT decision, my learned friend made quite a lot of the findings in the FTT. In particular, paragraph 172. But as my lady Simler pointed out, this is a counterfactual decision. If we had found that the other payments were not deductible on policy grounds. And the difficulty, of course, is deciding what is this counterfactual world in which the FTT are inhabiting in deciding this. It must be really a world in which they have decided that the payments do not have the character of penalties, they do not have the character of deterrence, and they are compensatory essentially. But of course that's completely contrary to the facts as they actually found them. So it doesn't help to have a finding on the basis of an entirely counterfactual world. My learned friend made a lot also of the choice.
Back, sorry,
I'm sorry.
to Malilieu.
Yes.
It is the object of the transaction, and that is determined on the subjective views of the trader making that. It's a rather odd test because in relation to those subjective views, you're not limited to what was consciously in the mind of the trader at the time, but you can look at other matters. And but the FTT relied upon the purpose of the regulator, and that's got nothing to do with it. Is that correct?
Not necessarily, no, because as I said, it can be an object of a payment to further someone else's purpose.
Right.
That's perfectly within Section 54. Or, sorry, it's something that you can take into account in deciding whether it's going exclusively.
And just picking up on what my lord has just said, is it right that it's that the subjective purpose of the taxpayer is determinative? It may be relevant.
No, it's not, and that's the point that was made most clearly in McKinley. The passage that I showed you in opening of McKinley, where they were making the point that some objects are so obvious that it doesn't matter what the taxpayer thought at the time. These are objects. And in my submission, this is one example of that.
So according to your argument, you rely on the deterrent nature of this, the punishment nature, the making sure you don't profit from your wrongdoing nature of it.
Yeah.
But are you saying that those are relevant because those are part of the intention of the regulator in imposing this? Or do you say those are just inherent in the character of the payment and that's why they're relevant regardless of whose intention was what?
Yes, I would say that probably
Well,
the latter is more accurate. They're part of the object of the
part
payment.
of the object, right. And it doesn't... So then you would say it doesn't really matter how Ofgem phrase it in their decision papers. They could describe it however they want, the nature of it.
Exactly, and they do describe it differently. And you'll find that, as do the taxpayers describe it differently. But that doesn't matter. I'm not relying on phrases that are used that you can pick out of documents. But more important is I think the point I think Lord Stevens was making earlier, which was if you look at the structure of this, it is calibrated as a penalty in inverted commas on, and you pay certain amounts, and then the question is, do you agree? Do the taxpayers agree to pay this by way of redress payments apart from £1 to charities or whatever? But there's no further discount for doing that. The whole thing has been calibrated to be a deterrent, to remove the benefit, etc.
But just to bring you back to Malilieu, again, at page 1155, letter D, Lord Brightman was looking at the taxpayer, the object of the taxpayer, and saying it's is not inevitably limited to the particular conscious motive in the mind at the moment of expenditure. Okay. But and then looking outside that for some other object. But it was still an object in the mind of the taxpayer.
Well, that's perhaps a rather philosophical question as to whether it was actually, it wasn't obviously actually in her mind at the time.
It wasn't.
But it's just an obvious, inevitable, I think described as inevitable object of the payment, whether you think about it or not.
Right.
I mean, if you think you're eating something, you're eating food in order to enjoy it, that may be your purpose, maybe your conscious purpose. But of course, one object of eating food is to survive. And you can't say it's not that because you don't think about it. So some things are just an inevitable consequence. That's how they put it in McKinley. In that case, it was buying curtains and whatever for moving expenses for partners. So can I just say something about the choice? My learned friend made a lot about choice. The problem with that is, of course, in this particular context, if the taxpayer had decided to take the penalty, perhaps because they wanted to appeal against it, they would equally have exercised a choice. It cannot be said that because they had a choice between the penalty and the redress payments, that whichever they choose is deductible because they've exercised a choice. The question is, what is the character of the payment, you having exercised this choice? And it's the same in both cases, whether you choose the penalty or whether you choose the redress payments. Just on Herald, if you look later on in the judgment of the majority, at page 1703, you will see that they actually deal with the penalty cases, Von Glen, and they actually distinguish the penalty cases.
So what's the page number again?
1703. They say that it's distinguished because the penalty is imposed as a punishment of the offender considered as a responsible person in obedience to the law. Its nature severs it from the expenses of trading. So they're making exactly the same point. It's inflicted as a personal deterrent and not incurred in the character of trader. In the end, this seems to come down to a battle between form and substance, as far as I can understand. My learned friend agreed that it was a matter of form, whether it's a penalty in form was determinative in my learned friend's case. He did say it was a penalty in substance, but that was only because where it went to the Consolidated Fund. But in my submission, that is the distinction that you've got to decide on. That's the battle. Is it whether it's a penalty in form that matters, or whether it's the nature of the payment, the substance of it which matters? And just finally on McNite, a small point, but the idea of the regulator taking account of the tax result is just unreal, frankly. The regulator would have to, first of all, have some tax experts, and they'd have to understand the tax profile of the taxpayer to determine what benefit or otherwise they would get from a tax deduction. They might have losses, for instance. It might not make any difference for years to them. So it's just, apart from the point I think my lady made, which is it's very difficult to see how that would be a proper factor to take into account in public law terms, but it would just be impractical. Just finally on McNite, two things to point out. One is, it was actually an issue in McNite at earlier stages as to whether the penalty was deductible. Before the Special Commissioners and before Mr Justice Lightman, the taxpayer was arguing the penalty was deductible. And you can see that, as I said, we've set all this out in our case describing. That point wasn't appealed to the Court of Appeal. So by the time you got to the House of Lords, that wasn't an issue. It was only the legal expenses. But the way Lord Hoffman reasoned in relation to the penalty in his decision was, in my submission, part of the ratio, in the sense that it was part of his reasoning, because he was faced with an argument by the Revenue, I think, that, look, the penalties are not deductible, and the legal expenses ought to be treated in the same way as the penalty, as they were in Von Glen, in fact. And his answer to that was, no, they're not treated in the same way, because there are two different policies involved here. The policy of the penalty is different, which he explained, from the policy involved in the legal expenses. So I would suggest, as I think I did below, that it is actually part of the ratio of the decision. Unless there's anything further, I think those are all my submissions.
Thank you very much indeed, Mr. Hewitt. Well, that brings this hearing to an end. I should say we're very appreciative of the members of the public who have stuck with us through this hearing despite the dry and technical nature of the argument. There's a reason why legal dramas focus on trials, especially criminal trials, because then you have witnesses and cross-examination and all the drama inherent in that. Appeals on points of law, which is what this court and indeed the courts below it deal with, are in their nature much drier and more technical exercises, but these are the places where actually the most important points get argued. And it's important, particularly for law students, but also for members of the public, that they have the opportunity to see this taking place. So thank you for sticking with us, despite the bone-dry nature of what you've been hearing over the last day or two. We'll now consider carefully all that we've heard, and we'll issue our judgment in due course. Now the court will adjourn.